Hello everyone, this is Dr.P.Syamala from the Department of MBA IB, Acharya Nagarjuna University. And today's our topic is regarding Indian Companies Act 2013. So, the topics covered under Indian Companies Act 2013 is regarding the features of Indian Companies Act, the types of Indian Companies Act, the types of the companies, and about the memorandum of association, articles of association, and about the prospectus of the company. So these topics will be covered under Indian Companies Act. So coming to the introduction of Indian Companies Act 2013, company is a Latin word. The origin of company, it has been taken from Latin word which means com plus panis, which gives meaning together bread. It means that an association of persons who took their meals together. So the original meaning regarding the Latin term means com plus panis is equal to together plus bread, which means an association of persons who took their meals together. The actual meaning is that one. But later on, in from 1844 onwards, in India, this concept has been taken. This concept actually has taken from the English Company Act, from 1844 onwards. Later on, some amendments have been made in 1850. So in 1850, this English Company Act has been changed into First Company Law in India, which is known as a Joint Stock Company Act. In 1857, Joint Stock Company Act limited with limited liability. This was introduced first time in India, in the year 1857. So there itself we have deleted the term English Company Act. We are using Joint Stock Company Act with limited liability. And afterwards, in 1913, 1913, in 1913, this Indian Company Act, has several amendments. After several amendments, again in 1956, another Companies Act has been taken over. So after 1956 Companies Act, after nearly 25 amendments, in 2013, another Companies Act has been introduced, with a new company bill. So under Act number 18, under Act number 18, this new company bill has been introduced in the year 2013. Actually, in 2013, the execution of this Companies Act came into existence with the assent of the president. But before that, in the year 2011, a bill was passed in the Lok Sabha, and afterwards in 2012, the bill was passed in Rajya Sabha, and finally, in 2013, this amendment has been made. A new Companies Act, has been introduced. And this 2013 Companies Act, with the Act number 18, with total chapters containing 29, 29 chapters, and the total sections included under this Company Act is 470. And coming to the total number of schedules are 7. So finally, in Companies Act 2013, how many chapters involved, the total number of sections, and the total schedules involved in it are the 29 chapters, 470 sections, and 7 schedules. So Before that, before 2013, okay, we have 1956 Companies Act. Okay, so under 1956 Companies Act, how many chapters we have, how many sections we have, and what were the total number of schedules we have means, in 1956 Companies Act, we have 26 chapters, we have 658 sections and 15 schedules. Okay, later on in Companies Act 2013, okay, chapters were increased from 26 to 29. Okay, and sections were decreased from 658 to 470, and the schedules also reduced from 15 to 7. Okay, in 2013. And now coming to what does a company means, what is the meaning of a company. So company is generally referred to as an association of persons, okay, an association of individuals, or else a voluntary association of persons formed for the purpose of doing business, having a distinct name and limited liability. Okay, distinct name in the sense each association has their own name. Okay, and at the same time the liability will also be limited. So here a company means a voluntary association, okay, which is formed for the purpose of doing a business, having a distinct name and limited liability. So we can say that it is a legal entity formed by a group of individuals. Okay, and according to section 2 subsection 20 of Companies Act 2013, okay, a company means a company formed and registered under this act or any previous law. Okay, so here there is no confusion. A company means a company formed and registered under this act. That is known as a company. Means under Companies Act 2013, okay, the company which is registered, or else the company which is formed, or else the company which is incorporated under certain act, which is nothing but Companies Act. Either it may be 2013, or else before 2013 we have 1956 Act, before that 1913, before that 1882, 1866, 1844. Okay, likewise from any of those acts it is declared as a company. Okay, now the Companies Act 2013 came into force with effect from 30th August 2013 with the assent of President of India. As I said before, okay, a bill has been passed from Lok Sabha, Rajya Sabha, and finally from 2011, 2012, and finally in 2013 August, okay, 30th, with the assent of the President of India, it came into force. And now coming to the definition given by Lord Justice Lindley. Okay, he gave a definition for a company that a company is an association of many persons who contribute money or money's worth to a common stock and employed for a common purpose. Okay, so according to Lord Justice Lindley, he says that association of persons, group of persons, okay, who contribute their money or equal to money, any worth of money, okay, to a common stock. Common stock is nothing but already some people are investing in that. So in that stock we also contribute there. Okay, so that is a common stock and employed for a common purpose, which is nothing but to do a business and get a profits. Okay, so the common stock so contributed is denoted in money and is capital of the company. So each and every person will invest some amount of money or money's worth in a particular company, which is nothing but a capital of that company. So the investment that we made, okay, which may be money or money worth in a which is known as a common stock. Okay, this stock is denoted as a capital of that company. Okay, and now coming to next part, the persons who contribute it or to whom it belongs are members. The proportion of capital to which each member is entitled is their shares. Shares are always transferable, although the right to transfer is often more or less restricted. Okay, so here what does this means the persons who contribute it to whom it belongs are members. So as I said before, the common stock, the people or the individuals, they will contribute some money or money's worth in the company. Okay, so that contribution of persons, they will be, the contributed persons will be declared as the members of the company. Okay, and at the same time, the capital, the proportion of capital, for example 5 members were contributed to a company. Okay, so each of them according depending upon their share capital. Okay, so to that proportion of capital, each member is entitled to their shares. Okay, so the member who contributed will be a member, the proportion of capital will be depends upon, is entitled to their shares. Okay, and it means that how much they invest, according to that shares will be allotted. Okay, and shares are always transferable here. Okay, though the right to transfer is often more or less restricted, means here restrictions can be seen in a private company but not in public company while transferring the shares. Okay, so and we can say that in private limited company there may be restrictions, but there will not be prohibition of shares, transferability of shares. It is very difficult to transfer the shares in case of private limited company, but it is not in the case of public company. Okay, so this is about the definition of the Companies Act regarding the Lord Lindsay. Okay, and what were the features of company? So these are all the features of the company. First feature of the company is incorporated association. Okay, so what does incorporated association means? Incorporation is nothing but the registration. Okay, so incorporation or registration under the Companies Act. So first feature of company means, if we want to have a company, definitely we have to register that company with the ROC. ROC is nothing but the registrar of the companies. If at all we want to have a company, if at all we want to keep a company, we have to go and register with that particular company. Okay, likewise, that is known as the incorporation of association. So this is the first and foremost feature of the company. And coming to a joint stock company may be incorporated under the act either as a private or public limited company. So after registration of company, we have to register that so and so company. Okay, so ABC company. So ABC company, private limited or public limited, we have to mention there. Okay, so this is another feature which is involved in the incorporation or registration of a company. And coming to the minimum number of persons required for the purpose of incorporation. So while we are going for registration of a company, there are certain rules and regulations to be followed by the public limited company or private limited company or OPC, one person company. Okay, so here what were the minimum number? So here minimum number is 7 for public limited company. Okay, so minimum number is 7 and maximum number is unlimited here in public limited company. Okay, and coming to here, second one, private limited company. Under private limited company, members will be 2 while incorporation. Okay, the minimum numbers, maximum limit is 200. Okay, and coming to one person company, here one person company itself says that here only one person will be there. Here there no nominee will be also there. Why? Because here the company itself is a one person OPC, one person company. Therefore here only one person will be there at the time of incorporation or after that. Okay, so these are the rules regarding the minimum number of persons to be there while incorporation or registration of a company. However, an association of more than 10 persons in case of banking businesses and in 20 in case of any businesses. So likewise, as we said, for public company, for private company, likewise in banking, okay, in banking the minimum number of persons is 10, and in other cases of businesses, okay, it is 20. Now coming to another aspect, if not registered as a company, okay, if we have not registered our company, then it may be considered as an illegal association, okay. So it cannot be treated as a legal company, okay. Therefore definitely every member who want to have a company, they have to undergo the registration process, okay. And also he has to say that whether it is a public limited company or private limited company or OPC company, okay. So the first feature of company is incorporated association. Now coming to the second aspect, separate legal entity or else the artificial person, okay. So what does separate legal entity means? A company formed and registered under the Company Act is a distinct legal entity, okay. So what does a distinct legal entity means? Means here distinct means difference, differentiated, okay. Differentiated in the sense, here in a company we will have members, okay, as well as the company will be there, and also members also will be there, which are who are known as the agents of the company. Because in order to function of the company, in order to have a functioning of the company, okay, through these agents the company works. So therefore members will be there in a company and company is also there. Here separate legal entity or else distinct legal entity means company is different, members are different, okay. We have company, we have members also, okay. So company is different from members, so this is known as separate legal entity. And here see, company is separate and distinct from the individuals who compose it. Even though people or else the individual form the company, at the end of the day company is different, individuals are different, members are different. No one can say that he is the owner of the company, okay. So the property of the company is not the property of the shareholders also. We have to remember it here, okay. So company, we will register the company name like ABC company or any other company name, but not the owner name of the company, okay. So there itself we may know that the person is different, individuals members are different, and the company is different, okay. So separate legal entity means, okay, the company and the members, okay, both are different, okay. So separate legal entity is there for company here, okay. So for this a famous case study is also there, like Salman versus Salman case. Here also in Salman versus Salman case, Salman is a person who carried on a prosperous business, okay, and he is a leather merchant and a boot manufacturer. And Salman formed a limited company consisting the members, all 7 members, with his family, okay. And here Salman sold his business to the company, okay. As he needed some amount, he sold his business to the company. So afterwards, whenever he sold his business and he draw his amount, after some period of time the company went into losses, okay. So when the company soon ran into losses or went into difficult situations, the debenture holders, okay, who appointed as receivers, and the company went into the liquidations, okay. uh, the unsecured creditors, they claimed the whole company assets, okay. They want to get their amount from that company, as the company is going to winding up, or else the company is going into losses. Okay, so that's why the unsecured uh, creditors means, as you know, the people who gave loans to the company. Okay, so now they are asking the company to repay their amount. They are claiming the whole company assets. Okay, why? Because the company is undergoing the losses, and they claimed on Salman, okay, that the company was a mere agent for Salman. Okay, so they claimed on Salman. Okay, but when it went to the before the justice, okay, the House of Lords, they rejected these contentions that were held by the creditors. Okay, why? Because they said that company is different from members. Company is a separate legal entity. Okay, so from the registration process onwards, company is different, members are different. It has its own existence, it has its own personality, it has its own property, it has a separate and distinct from its members. So we can say that finally a shareholder also cannot be equated with a company, even if he holds virtually the total share capital of the company. Okay, so this is the case of Salman versus Salman. Okay, so finally the creditors have lost their case. Okay, so Salman only he win in that case. So therefore, on the basis of company is a separate legal entity. Okay, these creditors has lost their money. Okay, so now coming to another feature of the Companies Act is limited liability. Okay, so limited liability means here liability is nothing but the amount we have to pay to others. Okay, so we are liable to pay some amount of money to the others, the agreed amount of money. Okay, so here liability, this liability may be two types. One is limited liability and the other one is the unlimited liability. So what does limited liability means? What does unlimited liability means? Limited liability means you have to pay as much as you have agreed to pay. Okay, so agreed to pay in the sense we will have a certain amount of shares. Okay, so for example, if you agreed to pay 10,000 amount of money, so you are liable to 10,000 amount of money only, not beyond that 10,000 amount of money. Okay, but coming to unlimited liability means, okay, unlimited means the liability is not limited, there is no static figure. Okay, like as I said before, in limited liability case a 10,000 amount, a static figure has been agreed. Okay, but here under unlimited liability, so whenever for example a company is winding up, okay, so if at all there is a 1 crore of liability means, so depending upon uh, the agreed or else the depending upon the worth we have given to that company, depends upon that. Oh, that you have to pay as much as you owe means that you have agreed, okay, to unlimited liability. Okay, to pay for unlimited liability. So unlimited liability means there is no specific figure like limited liability. Now coming to separate property, so company feature, another feature like separate legal entity. Here we will see separate property. Okay, so capable of ongoing, enjoying and disposing of property in its own name, so that is a separate property. So company is registered, okay, come on company's name, for example ABC Limited company, so it enjoys in purchasing of property or else disposing of property or else entering into contracts with the other companies. Okay, on company name only these all will be done, so therefore it is a separate property. The property of the company will not be considered as the joint property of the members constituting the company, although the capital and assets of the company are contributed by member. Did you understand? Even though the members contribute to the company, even though the members have shares in the company, even though the members have assets and capital in the company, okay, they are not considered, okay, they are not considered as the joint property, okay. So the property of the company only, the company has its separate property, okay. So this is about separate property. Now coming to perpetual succession, okay. What does perpetual succession means? So a continuity of business, okay. So unlike a natural person, a company never dies, okay. So even though the persons who are working in the company, like directors, even though if directors dies, any of the director dies, for example, the company will not stop there, the company will not end there, okay. The company continues. That is known as the succession, perpetual succession. Even though the directors die, even though the persons or members retire in the organization, okay, another person will come, okay. Even though the management changes, even though anything happens, but the company will be there only, the company never dies, okay. So where all member of company were killed or dead, in such case the legal heirs of deceased shareholders will become the member, but the company will not be killed, okay. So if at all the persons who are working there, or else the shareholders are there, if at all they die, their legal heirs, their children, or else their legal heirs, they will become the members of the company, okay. In that way the company will be in a perpetual succession, okay, continuity, it will not end. Now coming to another aspect, transferability of shares, okay. So what does transferability of shares means? Under section 56, the shares of a company are freely transferable and can be sold or purchased in the share market, okay. But this is applicable to only public limited company. As I said before, we have public limited company, private limited company, and OPC, one person company. But if we kept aside one person company, OPC, we have to deal with private limited company and public limited company. Coming to public limited company, their shares are freely transferable. There are no restrictions in public limited company, okay. But in private limited company, there are certain restrictions on transferability of shares. There are only restrictions but not prohibition. They are not prohibited but only restricted to some extent, okay. So therefore it is not that easy to transfer shares in private limited company, if we want to say in one word, okay. So transferability of shares is another feature of company. Means definitely a company is there, means definitely we will have shares, debentures, other things also, okay. So whenever these shares, debentures, all are these, there exists the concept of transferability. For example, if at all any shareholder dies, so what we have to do, we have to transfer those shares to their legal heirs. So at that time, if at all it is a public company, means there is no issue, they can easily transfer. But in case of private limited company only, there are certain restrictions, okay. So we can see only restrictions but not prohibition. I think you understand, okay. Now coming to another one, common seal, okay. So what does common seal means? Common seal in means a signature, okay, signature of directors of the company, okay. Who will do the signature? Means definitely the directors of the company. Why they have to do the signature? Means they have to submit this form to the ROC, registrar of companies, that you are going to have a company. So if at all you want to have a company, means definitely company should have directors. So those directors, minimum 2 number of directors should sign on that and should submit that form to the registrar of companies, okay. So if at all there are no if at all the company has only one director means definitely the company has a CS, which who is known as a company secretary. Okay, so with one director and the company secretary, both should have sign on the form which is to be submitted to the registrar of companies. Okay, so that is known as common seal, which is nothing but the signature that should be signed by the directors of the company and should be submitted to the ROC. Okay, and coming to another one, separate management. So what does separate management means? As we see, like a separate legal entity, okay, separate property. Likewise, separate management is also another feature of the company. So separate management means members will be elected, okay, their representative as director on the board of directors of the company. Each company will have BOD. BOD is nothing but the board of directors. So definitely these board of directors will be elected by the shareholders or the representatives of the company. So to conduct corporate functions through key managerial persons employed by them. So why these directors are employed means in order to do the corporate functions, top level management executive functions, the managerial persons are employed. Okay, so these persons are employed by the representatives of the company or else the shareholders of the company. So we can say that a company is a separate management. Why? Because the representatives of the company elect the directors of the company. Coming to another aspect, capacity to sue and be sued. Okay, so sue and be sued is nothing but, okay, um, going legally, okay, on the other one company, going legal action on the other company. For example, A and B, two companies are there. Okay, so here capacity to sue means A company can sue on B company. Okay, why? Because there are, for example, A company may be sued for infringement of copyrights, negligence and contempt of court by B company. Likewise, A company may sue for injury done to its business reputation by defamation on B company. Okay, likewise certain cases will be there like infringement of copyrights. Okay, so negligence, likewise injury that was happened to the company. So on all these type of different issues, okay, a company may sue or else may be sued. I think you may understand. For example, A company, it may sue on other company or else it may be sued by the other company, right? So as a company on incorporation become a separate and independent legal personality or artificial person. Okay, so as it is a separate legal entity, definitely a legality on legal aspects, a company may be sued or else it can sue or it may be sued by the other company. So this is about the capacity. Now coming to limitation of action. So what does limitation of action means? So for example, if a company want to have take any changes in the organization, in the business, okay, or else any changes regarding the administration or else any other contracts, if it want to take, okay, so it may not change the company aspects. Okay, so that is known as limitation of action. It cannot modify certain aspects. Okay, like we have in any company we have memorandum of association, articles of association, prospectus. These are all three documents that should be produced to the ROC before formation before incorporation of a company. Okay, so whenever we are going for registration of a company, definitely we should have these three documents, which are known as memorandum of association, articles of association and prospectus. So all these have certain aspects, certain rules and regulations according to the company law. Okay, so which cannot be changed by the organization, by the companies. To some extent, articles of association may be changed because it deals with the internal management of the company. But memorandum of association is not like that because it deals with outside of the company also. So therefore, it cannot change any aspects after producing MOA to the registrar of the companies. So this is a limitation on the organization. So limitation of action means it cannot change, it cannot modify after producing MOA. Okay, likewise the prospectus also. So once the power have been laid down in MOA, the company cannot go beyond such power. Okay, so that is limitation. Now coming to winding up. So winding up means we are ending the life of a company, means we are closing the company. We are not able to sustain in the market, we are not able to run the company, so we are going for winding up, ending up. Okay, so as a company is artificial person, it does not die as a natural person, therefore the life of company ends through a process known as winding up, right? Now winding up can be voluntary or compulsory. Voluntary means the company itself may feel that I may not sustain in the market, so I am winding up my company. And coming to compulsory aspect means here the government itself insists the company to wind up because of the situations in the company existed. Okay, means the company is unable to run the company. Okay, so therefore definitely the government involves, and it makes winding up of company as compulsory aspect. Okay, now however, to avoid this winding up company, if at all the company regrets, okay, it doesn't want to wind up means, then it may adopt some measures like mergers, amalgamation, reconstruction, reorganization. Okay, so going to all these aspects, why means in order to not to winding up the company. So all these situations will be done in this case. In compulsory means, if at all winding up of a company is compulsory means, at that time merger, amalgamation, they will think for all these aspects, or else voluntary. Okay, so this is about the winding up of a company. So all these are the characteristic features of the Companies Act. Okay.